go ahead and get the meeting started for the fuel metering and quality work group. It is approximately 10:04 on Monday, July the 27th. And I'm going to ask Delia to take a roll call.
Thank you. Mike Arismendes.
Here.
Wes Nats.
It's there. It's there.
Adam Thompson.
Present.
Siraj Ali. Mr. Ali, will you please unmute your microphone?
Yeah, I'm here.
Okay,
Thank you. Sorry about that.
sorry. Jason Harris?
Here.
Steve Boyd? Steve Boyd?
Here.
Lane Worthington? Lane Worthington? I saw him a little earlier.
Yeah, he's here. He's trying to.
Okay. Gary Garrison? I don't see Mr. Gary Garrison. Terry Maxey?
I'm here.
Steve Steve Webster? Sergeant Adam Colby?
Present.
Dan Hunter?
Here.
Brad Schulke?
Present.
And Stephen Skurlock.
I am here.
We have a quorum.
Okay, we're going to move on to the next agenda item, which is advisory work group member training. I believe, Mary, you're going to be leading that training.
Yes, thank you, Mr. Chairman. Good morning, everyone. This meeting is being conducted by video conference, and the public is watching via live stream. Any persons who signed up to make comment publicly will have a chance to do so later in the meeting. However, for this meeting, we have not had anyone sign up to make public comment. The meeting is being recorded and will be available on our YouTube channel. Here are some tips to make sure we have a successful meeting. Keep your microphones muted until you'd like to speak. Put all phones on silent and turn off any other sources of noise in your workspace. And if you're fidgeting around a little bit, then you're having everyone zero right in on you. So if you can, just kind of sit attentively. State your name before you begin speaking and raise your hand if you'd like to speak. Many of these platforms we're aware of have chat features. We're not going to use that because this is a large board and we have a lot of business to attend to. So we don't have time to look at the chat feature. Mike's not going to catch all that. So what we're going to do, raise your hand so it's visible on your feed. The presiding officer will call on you. Also, for any items that we vote on today, we're going to take a roll call vote so we don't have to count those hands. Ms. Delia will call a name and we will actually have a voice vote. If you have any problems connecting during the meeting, just let the presiding officer know. We have staff working in the office to assist with any connectivity issues. Finally, stay on camera during the meeting, even if you aren't speaking. Currently, I think we do have a member or two that are not on camera, and we will need you to show us yourself to participate in the meeting. If you need a recess, let the presiding officer know. Raise your hand so it's visibly on the camera. If you get inadvertently disconnected from the meeting, and this could happen, rejoin the meeting using the same link you used to initially join the meeting. We've done several of these now using this new medium. We've had a few awkward moments. I'm told more so internally than externally. We've had a couple of minor blips. No worries. We will deal with everything in real time. We will take a small recess if we need to. These things are anticipated and it's okay. Michael Fickle is standing at the ready with Kevin Harris to handle any items that we need to take care of as far as broadcasting this meeting. We will adjust. We will go through all the agenda items and we will take care of everything we need to act on. So I want to thank everyone for your participation today, and I look forward to handling this meeting. Mike?
All right, thanks, Mary. Board members, I want to move back up to roll call. And I believe we had two individuals that were not present, which was Steve Webster and who else were we missing, Delia?
Mr. Garrison.
Mr. Garrison, and also Carlos Garza.
Correct.
I believe those three individuals are not here, so I would entertain a motion to excuse their absence this meeting.
Mike, I move that we excuse their absence.
We have a motion by Mr. Harris,
Steve Skurlock, second.
second by Mr. Skurlock and Mr. Maxey. So all those in favor, just raise your hand and I'll see it. This will be an easy one to do. All right, sounds great. Motion passes. Thank you, and thank you, gentlemen. Let's go on to item D, which is approval of minutes for our meeting of February 27th. You've had the opportunity to review that meetings notes. If you have any questions, feel free to ask at this time. Any corrections, changes? If not, I'll entertain a motion to accept.
I'll move Mike, Steve Skurlock.
We have a motion by Mr. Skurlock.
Adam Colby, I second.
We have a second by Mr. Colby. All those in favor signify by saying, raising your hand. All right, motion passes. I will let you know that from this point forward, we will be taking a roll call vote on the public comments and anything else that would require a vote. So let's move on to item E. I do not believe we have any public comments. Anyone signed up or submitted any comments? Is that correct, Delia?
That is correct.
Okay, and no one has called in. So we'll move on to item F for the discussion, possible recommendation on rules for the motor fuel metering and quality program. I'm going to turn it over to Ms. Jessica Escobar for any for presentation of this item.
Good morning, Jessica Escobar, Assistant General Counsel. Good morning, Chair and members. It's great to see you all this morning. And I'll be presenting the new Administrative Code, Chapter 97, which are the motor fuel metering and quality rules. Let me go ahead and share my screen with y'all. All right, so while we're in this unique situation due to the pandemic, we were not able to meet virtually prior to publication of the proposed rules, but these are the same rules that y'all saw before they were filed. However, you'll note now that there are some additional edits to the original proposal, and these are the result of public comment and also to clarify some non-substantive issues that were identified by staff throughout the proposal. As background, the rules were filed with the Texas Register for public comment and were published on May 22nd. There was a 30-day comment period, and during that time, we received 4 comments. Since there were only 4, I'll briefly summarize them for you. The department received a question from an individual that was not a direct comment on the substance of the proposal, so I will not address that at this time. The department received a comment from the Texas Food and Fuel Association with no suggested changes. We received comments from Flint Hills Resources regarding the exemption of suppliers from device registration and device performance review requirements. The Texas Oil and Gas Association, or TXOGA, also submitted comments regarding the exemption of suppliers. TXOGA pointed out that suppliers are subject to strict testing protocols for accuracy at the federal and state levels. TXOGA also pointed out that suppliers were not subject to device registration requirements while regulated by TDA. As a result of these comments and for clarification purposes, a change was made to provide that suppliers are exempt from device registration and device performance review requirements, which is permitted by statute. As you can see on my screen, those changes in red are changes within the original proposal, and those are included in this proposal for adoption. And so that's what's there. TXOGA also submitted comments regarding the standards used for regulation of motor fuels. I'm going to go to those changes now. Specifically, they recommended removing specific years for each standard and broadly adopting language that would reference the most currently published version of the standard to ensure that industry and the department is conforming with the most up-to-date regulations. The department agreed and made that change. TXOGA also suggested additional changes to Section 97.3 regarding standards for regulation of motor fuel, and the department accepted those recommendations and has added language to ensure that there is specificity within the ASTM standards. And this is just for your reference, so you can see those changes that have been made. After discussion with industry and staff, Section 97.28 was amended to remove the requirement that device performance review records must be kept at the location where services were performed. The additional changes that were made to the proposal by staff were non-substantive and for clarification and consistency only. Members, I'm asking that you make a recommendation to the commission that these rules be adopted with changes at their next commission meeting on August 4th with an effective date of September 1st. I am available if you have any questions.
Any questions for Ms. Escobar?
Jessica, Terry Maxey, just for clarification, make sure I'm following correctly, the supplier exemption that was present in the previous TDA deal, and then also the supplier is real clearly defined in the statute and everything, so it's not going to be ambiguous.
It will not. And Mr. Maxey, so by adding that exemption within the sections for device registration and device performance review, we feel that adding a specific subsection within those sections to clearly identify that suppliers are exempt from those sections is in line and will exclude them from those requirements.
Thank you, Terry. Any other questions? Mr. Francis?
Mr. Chairman, before we take a vote and really technically on this very historical moment, I want to thank Jessica and all the team that's done so much work on this, the work group and the work that they put in beforehand. There have been 1,000 conversations on these rules and going over them and making sure that they're fine-tuned and that they really represent the best collaborative document that we could come up with. I'm really proud of the work that's been done. I will tell you that this is a beautiful work of art, but it's not perfect and it's not permanent. This is a starting point. We want to get a sense of getting our program in place, figuring out if there's any gaps that need to be filled as we move through it. But I'm really, really proud of the work, and I just wanted to commend Jessica and all the folks that have worked on it, Stuart, and I can go on and name 1,000 people, and I'll miss the 1,001 person. So thank you guys for all the work. Thank you. Appreciate it.
Thank you, sir. Yeah, there's a lot of effort and work put into this. Thank you, Jessica, for this. Thank you, Stuart. Any questions on the rules? Seeing none, I'm going to ask that Delia do a roll call. At this point in time, I'll accept a motion to accept the rules as presented with an effective date of September 1. Is that correct, Jessica?
That's right.
So with effective date of September 1.
I move that the rules be effective for accepted effective September 1.
Motion by Wes. Nance.
Yes.
Second by Mr. Terry Maxey.
Yes.
Okay, we have a motion and a second. Delia, will you call roll, please?
Mike Mendez,
Yes.
Wes Nance,
Yeah.
Adam Thompson,
Yes.
Siraj Ali,
Yes.
Jason Harris,
Yes.
Steve Boyd,
Yes.
Lane Worthington,
Yes.
Terry Maxey,
Yes.
Adam Scott Cody,
Yes.
Dan Hunter,
Yes.
Brad Shilkey,
Yes.
and Stephen Young. Skurlock.
Yes.
Motion passes.
Okay, we have a motion passed as was stated earlier. The rules will now go before the commission that has a meeting scheduled for August the 4th. Thanks for all your work. I would make real quick note that on my screen, you guys keep bumping around, so I wish you'd stay in place because I'm looking for one person and then you guys will move somewhere else. So stop, keep up. So if you don't mind, I'm just kidding. All right, let's move on. Item G, discussion and possible action to recommend approval of the criminal conviction guidelines. I believe we have some individuals that have joined us from Tdlr. Tony Reed, Chris Russey, Ken Sharp, and John Medlock, I believe, are on to be able to discuss that. I'll turn this over now. I'm not sure who's going to begin this. Who's going to be heading this up, John?
I will take care of it. This is Ken.
Okay, go ahead, Ken.
All right, thank you. Good morning. My name is Ken Sharp. I'm one of the 3 Enforcement Division prosecutors here at Tdlr who works with criminal background investigations to determine license eligibility.
Hey, Ken.
What?
Do you have a video? We can't see you. If you have a video, we'd like for you to turn it on.
No,
Okay, that's fine.
we had a problem with that before we started, and
No problem.
we never could get it worked out. So you don't get to see me, or you don't have to see me. I guess it depends on your perspective.
Okay, go ahead and proceed.
Okay, anyway, back to story. We're here with the criminal conviction guidelines, or proposed criminal conviction guidelines for the licensed service companies and the licensed service technicians. Tdlr uses these guidelines to determine whether a person's criminal record should disqualify that person from holding a license that we issue. The state law requires criminal background checks for people who apply for these types of licenses for individuals, but also for controlling persons of companies. And that's in Chapter 2310 of the Occupations Code as it is now. Now, the state law also requires agencies that issue licenses, occupational licenses, to compile a list of criminal offenses that are directly related to the duties and responsibilities of licensed occupations. Those offenses that are directly related to a licensed occupation can disqualify the offender or the licensed applicant from obtaining or continuing to hold a license if they already have one. These guidelines that you have before you today, these were developed by a smaller work group that consisted of Tdlr staff from the Enforcement Division and some members of the entire FMQ work group. That's what we call FMQ, fuels, meter and quality, and so forth. Anyway, that's our acronym. We like acronyms. We were glad to be able to work with the members of the work group. They helped us understand the companies and the settings in which the technicians work, the types of clients they serve, and the nature of their contacts with clients. We had some really informative suggestions and conversations about what kinds of crimes should be a possible basis for denying someone a license. We met back on June the 4th, and that was electronically, like this kind of, not in person. It was a bit of a challenge, but everybody's really good about working through that little challenge. Before the meeting, now the Enforcement Division staff had prepared a rough draft of what we speculated should be in the guidelines. And then during the meeting, the motor fuels experts in the work group offered suggestions for things to include and some things to exclude, things that didn't matter. And that was great because those were things that we didn't think of. And we reworked that rough draft that we started with into a more sophisticated product based on input from the work group members. And then afterwards, we sent out a copy of what we drafted, the results of our meeting, that is, to everybody by email for additional comments and suggestions. What you see here today is the process, as a result of that process. And of course, we want to thank those of you who worked with us on this. Your help was extremely valuable. Actually, it was crucial to us understanding this field and what should be expected of people who work in it with respect to the criminal background. Anyway, that brings us to today, and we're having this meeting today to get your official input on these proposed guidelines. We're going to ask you as a group to approve them and then recommend approval by the Commission of Licensing and Regulation. I want to explain a little bit about the agency's process for criminal background checks. We, here at Tdlr, we look at several laws that give us the authority to deny or revoke a license based on criminal history. Primarily, we look at Chapter 53 of the Occupations Code. That's our general authority for denying licenses based on criminal history. In 53.021A, it says that an agency may suspend or revoke or deny a license to a person who's been convicted of a crime that directly relates to the duties and responsibilities of the licensed occupation. That's where we are with these criminal conviction guidelines. Those are the ones we've identified that directly relate to the duties and responsibilities of this occupation. But I want to tell you about a couple more. In Chapter 53 there, they also authorize the denial or revocation of a license for crimes that are listed in a certain part of the Code of Criminal Procedure. And these are the really bad things, the really heinous kind of crimes like murder, capital murder, indecency with a child, aggravated kidnapping, aggravated sexual assault, aggravated robbery, and so forth. It includes any felony, actually, that involves the use of a deadly weapon. And it includes a multitude of drug offenses if they were committed within a drug-free zone, generally places where children are present. The third category would be what's called sexually violent offenses. They're defined or enlisted in the Code of Criminal Procedure in another place. And they include things like indecency with a child, sexual assaults, aggravated sexual assault, sexual performance by a child, aggravated kidnapping committed with intent to violate the victim sexually, and so forth. All of these things, again, these are really bad, but they have more of a sexual connotation to them in that third category. And you might look at this and you might say, well, it seems to be like there's a lot of overlap here. There's some of these offenses that appear in two or all three of these categories, and that's true. There is a lot of overlap, and that's okay, because it's better to have all those covered twice than not to have them covered at all. There's also some provisions in your statutes in Chapter 2310 of the Occupations Code that identify some specific acts that constitute criminal offenses in the context of your occupation. Obviously, the legislature already looked at that and decided that those are directly related offenses. So we included a general reference to those in the guidelines. And so they are also going to be relevant to any criminal history analysis that we do. And of course, that would be in the context of the directly related offenses that authorize Tdlr to deny a license application or revoke an existing one. And that takes us back to Chapter 53. These guidelines that you have here, they actually serve more than one purpose. For one thing, they identify, of course, as we know, the directly related offenses that would authorize Tdlr to deny or revoke a license. But they also put the industry and would-be applicants on notice about what those directly related offenses are, whether they're going to have a good chance at this. The law also requires us, every agency that issues occupational licenses, requires us to state reasons why a particular crime is considered to relate to a particular license. So that information is also going to be available to all interested persons as well, including those potential license applicants. One more background item. Sometimes people want to know about our process, so I'm going to tell you just a little about that. Every person who applies for a license or applies to renew a license here at Tdlr actually undergoes a criminal history background check. We have 3 attorneys here who review the criminal records of those applicants and current license holders. And every day we get a stack of criminal records and some other information that we examine, looking for convictions or deferred adjudications for directly related offenses or those especially bad crimes or sexually violent offenses I referred to a few minutes ago. And if we don't see anything to be concerned about, that's fine, and that's the majority of what we look at. We clear the person to receive a license. That's what happens most of the time. If we do see something that might cause concern, then we'll open an investigation, or open a case for investigation, rather. A Tdlr investigator finds out a little bit more about the offense, or offenses, plural, because that's usually what it is, and reports the information back to one of the 3 prosecutors who works with these kind of cases. And we might get copies of court documents or police reports to get even more information. There will be times we might ask the license applicant for evidence of rehabilitation efforts or letters of character reference from prominent people in the applicant's community, people who know the applicant and know the applicant has changed for the better, is now doing well and not likely to reoffend. When we have all the information we need, we make a decision. We'll either clear the person for the license despite the criminal record, or we'll send the person a notice that we intend to deny the application. And it works basically the same way with a renewal application, although the technical notice procedures are just a little different. Anyway, when a person receives a notice that we intend to deny the application or deny the license, the person can choose to move on, or the person may ask for a hearing to contest our decision. And those hearings are before an administrative law judge or ALJ up at the State Office of Administrative Hearings, which is also referred to as SOA. Those hearings are a lot like a trial you might see on TV, although they're not nearly as dramatic. At the end of the hearing, the ALJ will take the evidence back to the ALJ's office and consider it all, and then write a proposal for decision, or a PFD. I told you we like acronyms. In that PFD, that's a recommendation to the commission as to how to decide the case. It's the responsibility of the commission to make that final decision, and that's why the ALJ only submits a proposal for a decision, or that recommendation. The commission considers the matter at one of its meetings, and then makes the final decision as to whether the person should get a license or whether the application should be denied as was originally proposed by Tdlr. Now, I'll tell you that these cases are not foregone conclusions. Neither the ALJ nor the commission just automatically adopts whatever we at Tdlr propose. They don't rubber stamp anything. They study these cases independently, and they reach their own conclusions about these cases. Just a few final points on this. We do not hold an offense against a person forever, and we're a little bit more lenient with isolated or minor offenses. I can give you one example. A 19-year-old in college leaves the frat party and gets a DWI, but maybe 10 years later applies for a license. If that's the only thing that's on that person's record, we're almost always going to issue the license. Not that DWI is minor, by the way, but under those circumstances, it would not likely disqualify an applicant. And also, even if we deny a license for now, it's not necessarily forever. Suppose we deny a license because the person was involved in several thefts and maybe some forgery or credit card abuse offenses, and they were all within the past 5 or 10 years. Well, yes, we probably would deny that license application. But suppose another 5 and 10 years go by with no more offenses. Well, we would be much more likely to issue the license under those circumstances, especially if the person has letters of character reference and has established a record of good conduct. So we don't hold those things against a person forever, but we do always keep public safety and consumer protection in mind. So that's our process in a nutshell. Does anybody have any questions on this? And I can't, I don't know if I can't see all of you. I just see a few blocks, so you'll have to just.
Anybody have any questions for Ken on the criminal conviction guidelines?
Well, I'm not through the guidelines, just on what I've been through so far.
I'm sorry. Based on just what the information he's given right now. My apologies.
Okay, well, good. Then, if there are no questions, we'll just go through these guidelines, look at those one by one, so we can tell exactly what we have here. You'll see kind of a pattern here. We don't list specific crimes, but categories, rather. A good example is in the first one, crimes involving fraud or deceptive trade or business practices. If we were to try to list every single offense, we would go crazy. And we'd always have to be revising this thing frequently because we've got 50 different states. Even in the state of Texas, we've got 254 different counties and different court districts and counties. They have a tendency to name things different, even though they're using the same statute or using the same, or they're referring to the same offense. But like I said, we've got 50 different states and a District of Columbia and some other possessions and so forth. So all of those things, not to mention the federal law, don't forget that. All of those things are different. And so in order to make sure we don't let something slip through the cracks, we put these in categories. So the first category, crimes involving fraud or deceptive trade or business practices. That's going to cover, that's pretty broad. It's going to cover a lot of things, no matter what you call it. When you look at this one, you also see, as I said earlier, that we have to list reasons why this would be directly related to the duties and responsibilities of a licensed occupation. Those reasons are listed here. You see 3 of them there, and I know that you all probably had an opportunity to read them yourselves, and I won't read them for you. And you can see them up on the screen. I understand Chris has those up on your screen so that they're available. But if you do have any questions on these, chime in as we go, and we'll make sure we address those. The second one there that you see is those are the crimes that involve bribery, forgery, tampering with records, or perjury. A lot of dishonesty listed there. And there's a lot of ways you can be dishonest and get charged with something along those lines, even though it may not have the same name. But we've also included that because, of course, we like trying to avoid people getting licensed who are involved in fraud or deceptive trade or business practices. We also want to avoid licensing people who are involved in these dishonest practices. Now, any questions on those? Okay, the next one. This is the category of crimes that involve unauthorized interception, acquisition, possession, or use of financial account information, such as credit cards, debit cards, or bank account information. This kind of addresses a pretty broad, like I said, it's a pretty broad category of crimes, and it should also address those skimmers in there. But I think it was Sergeant Colby who suggested that we add a separate category that would make double dang sure that we got those, and we'll get to those in just a minute as well. But people who commit credit card abuse, debit card abuse, steal financial information, those kind of things, they probably shouldn't be in this occupation if they have a disposition a predisposition to do those kind of things. And so that category is in here. Any questions on that?
You don't have any questions? Yes. If not, I would also make note that Mr. Gary Garrison has joined the meeting. It's good to have you here, sir. Go ahead, Ken.
Okay. All right. Thank you. Next category, those are the crimes that involve racketeering, organized crime, or criminal influence, and I think that speaks for itself. That can be kind of... then we have the crimes that involve the interference with or refusal to allow sample collection and or testing of motor fuels and those other things. These are the things that specifically are addressed in Chapter 2310 of the Occupations Code, as I mentioned earlier. And so there's a list of things in there that if they're going to be doing those things, they don't need to be in this occupation. Environmental law violations. It's kind of amazing to me. It was surprising to me when I first started doing this, the number of people who commit environmental law violations, illegal dumping and of toxic chemicals and things like that. And there's the opportunity to do that in this particular occupation. So we don't want somebody who's predisposed to that kind of conduct to have licenses. We've got some more honesty integrity type crimes here, those against property such as arson, theft, criminal mischief, or burglary. We want, again, public safety, consumer protection, and we want to make sure the consumers are not going to have things stolen from them or torn up, or burned up. Gasoline, that's a good starter for fires. Anyway, we've got that. We've got the reasons for that listed as well. The next one involves the use, possession, manufacture, or delivery of controlled substances, dangerous drugs, or other dangerous substances. This is dangerous work that you're in. And these folks who travel around from one place to the next to be involved in this type of work and who are actually doing the testing and all those kind of things, they need to be sober and they need to be fit to do this kind of thing. And so this category was deemed to be an appropriate category of criminal offenses that are directly related. The same holds true for those that involve intoxication from alcohol, drugs, or controlled substances and so forth. And also that previous one, that because you can, or because people in this industry are moving around all the time, it gives them an opportunity to move unsuspiciously from one place to the next and be involved in the delivery of controlled substances and so forth. So we want to avoid that as well. Okay, then we have the crimes against the person, such as homicide, kidnapping, and assault. We don't want violent people to be licensed to doing this because you're going to have contact with others, either at the businesses or test sites and so forth. So if there's going to be a confrontation, we don't want it to end with a violent response. This next category is one that's in the vast majority of the occupations that we regulate, and that's the crimes that involve prohibited sexual conduct and public indecency. And of course, you can see the reasons for that there. And they're self-evident, I believe, but we also have listed them there as the statute requires. Our society has always moved to protect those who are most vulnerable among us. That includes the children, the elderly, or the disabled as victims, and so that category is here as well. That's the last category. Are there any questions on any of those?
Any questions for Ken? Okay, go ahead and proceed, Ken.
Okay, thanks. Well, those are the proposed criminal conviction guidelines for the licensed service companies and the licensed service technicians in the motor fuel metering and quality program here at Tdlr. As I said before, these guidelines were developed with a lot of input from members from this work group, and for that reason, we think they are ready. And again, we appreciate their help with this. It was tremendous. We're asking you today to vote to recommend these guidelines for the Commission's approval. Thank you.
Okay. I'll go ahead and open up for any questions. I know that it's my understanding that this is a new phenomenon for this industry. I'm not sure if we had this prior to, but this is kind of a staple within TDLR. We always have some guidelines that we use for the different industries. You see this framework built into a lot of the programs that we administer. So we now want to bring before you this consideration. And I'll open up to any questions or comments at this time. Seeing none, I'll go ahead and entertain a motion to accept.
Motion.
We have a motion by Mr. Maxey,
I'll second.
second by Mr. Thompson. Ready, will you take roll, please?
Mike Arismendes,
Yes.
Wes Lance,
Yes.
Adam Thompson,
Yes.
Siraj Ali,
Yes, ma'am.
Jason Harris,
Yes.
Steve Boyd,
Yes.
Lane Worthington,
Yes.
Gary Garrison, Mr. Garrison, can you unmute, please?
How's that? Yes.
Kobe,
Yes.
Dan Hunter,
Yes.
Brad Schulke,
Yes.
and Steven Skurlock.
Yes.
Motion passes.
Okay.
Passed here for this. It will now go again before the commission. So what I'm going to do, I'm looking at the time right now, it's 10:45. What I'd like to do is to jump down to item I, our staff reports. And we're going to have David Gonzalez, our Deputy Executive Director. He's going to bring before us kind of an update on our COVID situation and strat planning. And then Deputy Executive Director, also Christina Kaiser, will talk about our sunset process. And I believe our Executive Director will serve as a little commentary on the side, plugging in certain comments. As we forget things, he has a tendency to let us know. So, David, if you don't mind, I'm turning it over to you.
Good morning, Workgroup members and public viewers. My name is David Gonzalez, Deputy Executive Director of Licensing Services. I hope to share my screen with you right now so that I can have the pleasure of sharing a portion of the executive report today. I picked the right one here. May have a slight delay, but y'all should be seeing a Google Chrome screen come up in just a moment. Everybody see my screen? If someone could give me a verbal yes, I can't see any of the little.
Yes, I can see you.
Yes. God bless you. Thank you very much. So we're going to start off with COVID-19. the entire world has been affected by COVID-19, TDLR included. The approach that we've taken, I can describe, and this is going to be a very brief presentation, is both an external and internal approach. For the external approach, we've tried our best to be a conduit of information for the public that we serve. If you go to our webpage, and that's the reason I brought the page up, you should see at the very top of our main page, this block right here that takes you to the information that we have provided in regards to COVID-19. If it affected a particular program, we may have given special issuance of information that goes specifically to a program. I'll show you an example here. We had continuing education requirements for offender education program. It's at the top of the page. If you scroll down, you will see a historical issuance list of all the things affecting the different programs. So if you want to stay in touch with what's happening with your particular license or your particular program as it relates to COVID-19, this is the place you want to keep in touch with. On the right-hand side of this page, you'll notice we have all the governor's executive orders on the side that may have affected the information we put out. We also have links to the Centers for Disease Control, which had to provide us a lot of the guidance, as well as the Department of State Health Services, which provide a lot of the guidance that we utilized to get the word out to the programs that we serve. So the external approach, we were the conduit of information, trying to interpret, understand. Remember, all this stuff is happening at the same time that we're reading the information from the CDC and from the governor's office. We're trying to figure out how do we explain it to the public we serve so they can use that information and take the actions necessary to do their business. The other approach, or the other aspect of COVID-19, is our internal approach. We too were affected by COVID-19. We too have staff that have been affected personally by contracting COVID. So we've had challenges ourselves. At present, we are in a return to office mode. We have been working from home since March. It was a trial period we were going to conduct to see if we could do it. When the mandate was said we need to try to work from home, the executive office said we're going to try it, we're going to do our best. And I tell you what, our IT group came through with flying colors. They set us up quickly. Some of our positions at our agency were not necessarily going to be working well from the home environment, and we've had to maintain rotation of people still coming into the office, especially our financial services and our licensing division staff who have to get mail and have to open up applications. That has been a real challenge for us to keep up with those things, but we have maintained, and I would just like to congratulate all of our TDR staff for the hard work and diligence they put in, keeping up with the mail, dealing with our own personal health situations, and still maintaining the business of serving the public. It has been a challenge for us, but we are learning lessons that we will be able to utilize for years to come. This pandemic situation is one of those situations that everybody is going to find new ways to do business. And I don't think we're ever going to be able to go back to the standard way of just reporting to an office and sitting in a cubicle and doing our work. Now that we know that we can, it's basically a ball and chain between cell phones, smartphones, and laptops. We could have our staff working 24/7 from anywhere in the state of Texas, but we have to embrace that technology, and including these virtual meetings, which have, we've had a few glitches along the way and we're still learning, but they've been a great success for us. So that's our response to COVID-19, external and internal. And if you want any information in regards to your programs, this is the page to go to. The next portion of the presentation, oh, I'm sorry, Mr. Francis or Christina or Mr. Adis Mendez, is there anything that I've forgotten or overlooked in the presentation for COVID-19?
I think you're good from my perspective, David.
Yeah, you're good, David. Keep going.
All right. So next we have strategic planning. I will show you where it's at, and then I will go to the actual page. On our main page, if you scroll down, and it's important that everybody, especially the public, know where this is at, because this is our roadmap. This is the agency's plan going forward. Organizational reports, strategic plan for 2021-25. So every state agency is responsible for submitting a strategic plan to the governor's office. Ours is called Leading Texas to a Brighter and Stronger Future. Again, a very brief presentation over this information, or as brief as I can be. I tend to be long-winded because I get excited about the topics that we talk about. But important, the table of contents. You're going to find it lists who we are, what we believe, who we regulate. This is a standard in many of our strategic plans. How we do our business. These are things I want to touch on because I think it's important for everyone to see themselves in this plan, including our agency, staff. We got core values and goals listed throughout the strategic plan, but I'm going to stop on just a few spots so that you can see yourselves in this plan. Excuse me if I'm making you dizzy. I'm trying to scroll to y'all's page and y'all's table. Oh, too far. I think there's a delay. Here we go. All right, so motor fuels, metering, and quality. You'll see yourselves a strategic plan with the numbers we have listed. You'll notice this small asterisk. We are currently undergoing sunset, which will be presented by Ms. Kaiser, but y'all's program is not included. We have a limited scope review for sunset, but that sunset review is going to be affecting the strategic plan. In fact, it's a significant part of the strategic plan because it's dedicated goal number 1 that we adhere to and try to implement the recommendations that Sunset has advised us on. A very important part, and this agency has grown significantly because of Sunset direction and actions that have been taken in the legislative session. How we do our business, obviously we're overseen by a governor-appointed committee, the Commission of Licensing and Regulation. These individuals provide us guidance and direction on the things that we do, and because they're not allowed to actually have any invested interest in a particular program, they're able to have an unbiased input and provide us the guidance that we need to make sure that we're doing the best we can for each of our programs. Just like this work group is so critical to our decision making, we have advisory boards that give us information and guidance. We used to have a smaller amount of advisory boards. We have 33 advisory boards now to keep up with. So kudos to Tdlr and the advisory board staff, Mary Winston and her staff, because this can be difficult. Now, we don't have the logistics of travel anymore. With virtual meetings, it's a different kind of logistics that we have to coordinate, but I think it makes us more effective. There's more people that can participate, and actually just seeing y'all's faces on the screen brings a whole new dynamic to the input that we receive from our advisory boards. I think it's improved the communications, or at least the opportunity for communications with our advisory boards in these COVID moments. I'm going to scroll on down how we do it. Obviously, the 3 deputy executive directors with their Mr. Francis, all supporting the executive operations. I'm going to scroll down quickly to our actual goals. Not as fast as I'd like, but it's getting there. So, our agency goals, what we're planning to be. We are going to fully implement and administer the recommendations resulting from the sunset review process. That is a significant goal because there are significant and several recommendations from the sunset review. So we made it our number 1 goal. It is in our interest. It's in the agency's interest. We're already looking at management actions that have been recommended, but there's got to be legislative action as well. And I'll let Ms. Kaiser get into that when we start talking about sunset review. Goal number 2, improving efficiency, streamlining rules, decreasing regulatory burdens. These are things that we've maintained through our previous strategic plans. We're not going to give up on that. That's still goal number 2 in our process. We're going to continue with that. Protecting the public, health and safety, consumer harm, things that we've done in the past. This is probably the only other one that's significant to this strategic plan. We've incorporated a goal of positioning Tdlr to respond effectively to the next pandemic, natural disaster, or crisis. We've reacted pretty well, we believe, as an agency in times of hurricane and tornadoes and flooding disasters. But this pandemic is a whole new realm for us, and we've had to do our business differently. It's actually changed the core structure of how we do our business at Tdlr. We want to position ourselves for the future and make sure that we've got the resources in the right places with the right equipment so that we can do our business no matter what kind of disaster occurs, or God forbid, the pandemic continue for longer than we would hope. Those are a couple of the points that I wanted to make specific highlight on, just so that y'all can know that this strategic plan, if we're not here, if y'all aren't getting a special presentation from us, you want to know what the plan is for Tdlr, you can go to the strategic plan and find the roadmap for Tdlr. Mr. Francis, Ms. Kaiser, Mr. Mendez, is there anything I've forgotten? in that presentation.
I don't have anything. I don't know if there's any questions or Kaiser, if you have anything to add.
I do not regarding the strategic plan, no.
Are there any questions from the work group? I would invite you to go to our website and take a look at that strat plan if you get a chance. Or maybe if you just have some insomnia one night and don't know what to do, you can read that. But it does give kind of a roadmap of what we're looking at doing at the agency and how we intend to improve our efficiency. So, if there's no questions at this time concerning the strat plan or the COVID response that we've had, I'll now go on to Christina Kaiser and let her bring you up to date on our sunset that we're trying to go into.
Good morning, work group members. I'm Christina Kaiser. I am the Deputy Executive Director for Regulatory Services here at Tdlr. My area of responsibility includes the enforcement, field inspections, and regulatory program management divisions. I'm going to tell you a little bit about our sunset process and events that are upcoming. So as you're probably aware, every agency is subject to review by the Sunset Commission on a periodic basis. Typically, it's 12 years. And so Tdlr came up for review last year. I believe our reviews by the Sunset staff started in September of last year. And they have spent many months having many meetings with agency staff and really digging in to understand how we do things at Tdlr. So on May 14th, the executive staff had an exit conference with the Sunset Commission's staff, who at that time told us, you know, as a preliminary matter, what they thought their findings would be. And so we had some conversations about those. And then on June 4th, the Sunset staff's official report of recommendations relating to Tdlr was published. Tdlr's response was provided on June 25th. And thereafter, or starting, I guess, on June 24th, public input from anybody in the world who wanted to offer input was accepted by the Sunset Commission. So the staff report provided by the Sunset Commission is available on the Sunset Commission's website, and there's actually a link to that on Tdlr's main webpage, kind of on the top right-hand corner. You'll see a link to that, and you are welcome to go there and read about the report. And when you go through the report, you will see that there are two kinds of recommendations offered by the Sunset staff. There are recommendations for statutory changes, and then there are also recommendations for management actions. The statutory recommendations, of course, require that a bill be filed in the legislature and that it moves through successfully and gets passed in the legislative process. So those actions would be moving through the next legislative session in 2021. The management action recommendations are things that don't require any change in the law, but they're recommendations to Tdlr to change something about our processes or our policies. So regarding the management actions, Mr. Francis has created a team of us that includes me, who are already working on moving forward with some of those management actions. They come in various categories. Some of them are, you know, standalone, sort of quick, easy to accomplish items that we don't think anybody will much object to, and we're already moving forward with some of those. Some of the others are more complicated and will take longer to accomplish and will involve in interaction with a whole lot more people, like advisory boards and industry people. And so we will be moving forward on those, but they'll of course take longer to accomplish. Some of the management actions are areas where we simply want to sort of figure out the mechanics of how we would accomplish that thing, but we expect that it might be controversial. It might be objected to by some of the regulated industry, or perhaps the Sunset Commission won't like the idea when they ultimately vote on it. So we have one category of management actions that we're sort of figuring out how we would put it into action but we're not actually going to put it into action until we get more guidance from the leadership. So what comes next? We're already, as I said, moving along with some of the management actions, but this is a long process and it's far from over. So on August the 20th, the Sunset Commission, which is the actual decision-making body, will hold a public hearing about TDLR. And at that time, they will be accepting public testimony from anyone who wants to offer public testimony about TDLR and about the recommendations in the Sunset staff report. And then on September 24th, the Sunset Commission will hold a decision meeting and they will actually vote on the recommendations contained in the Sunset staff report. Now, at that stage, as I mentioned earlier, the process is still not done because those legislative change recommendations, if adopted by the commission, are still just recommendations at that point. They still have to be placed in a bill that will work its way through the legislative process at the next session. So it's a very long game, and we are well on our way to seeing some changes as a result of the process. One thing that I wanted to mention that Brian has mentioned several times, even if all of the recommendations that are contained in the Sunset staff report ultimately don't get adopted by the legislature, this has still been a very good process for us. TDLR prides itself on being an expert in regulation, and we feel we do many things well, but you don't really know that until your processes are examined and tested by someone from the outside. So whatever comes out of the legislature, we feel we will be better off for having had this review. I'm going to end there. I'm happy to answer any questions if you have them.
Anyone have any questions for Ms. Kaiser? Let me tell you that the sunset process has been very good for us, of course, as Dan Hunter can attest to, because the Department of Ag are currently going under a sunset review at the same exact time. So he could probably tell you the painstaking process of going through this, but it is healthy. It's good to know, and it's good to be able to go through to be able to see where we're at and what we're doing, and get some suggestions from a staff that's totally independent from our agency that can kind of get in there and take a look. As they used to say back in the day, look under the hood, and to be able to see where the inefficiencies are. So it's been a good process for us. Any questions for Mr. Gonzalez or Ms. Kaiser concerning anything that we've mentioned so far, COVID, strat planning, or sunset? Okay, there being none, we've been at this for about an hour. So why don't we take about a 5-minute break, and then we will come back and we'll finish up with the penalty matrix and talk about any agenda items for our next meeting. So it is now 11:02. Let's try to get back over here no later than 11:10. All right, thanks. let's go back to agenda item I. I'm sorry, H. I appreciate your indulgence in this. The reason I pushed up or pushed the item H down, the penalty matrix, this also is somewhat new in that it's based on how we conduct business at TDLR. I would let you know that there was a subgroup that met from this work group to meet with our staff concerning the penalty matrix. There was a lot of discussion, a lot of really great discussion that we had on this. And for those work group members that were involved in that, I will let you know that we've taken your comments that you made. There were some changes made to the penalty matrix, so you'll see that as it comes across. I believe, John, are you or Chris going to be kind of tag teaming this also?
Chris will be this is John Mellock, Chief Prosecutor. Chris will be putting it up on the screen, but Tony's going to be walking them through it, and I'll also be available to answer any questions.
Sounds great. I appreciate it. This was a lot of work that was done, and internally, we met last week also after our subgroup meeting and went through the comments and suggestions made by this work group, so it turned out to be really productive. I would also make note that despite the Director of Enforcement's lack of ability, that our prosecutors have worked out brilliantly in this. So I told him that I was going to say that because he was bad-mouthing my Texas Tech Raiders. So I'm going to go ahead and turn this over to Chris. Has it on the screen. I'm going to go ahead and turn it over to Tony, who's going to take you through this penalty matrix. Go ahead, Tony.
My name's Anthony Reed. I'm a prosecutor in the Enforcement Division. About half of what I was going to say in the first part, Mr. Mendez handled for me. Myself and Prosecutor Michael Shirk took the first cut at the matrix. Afterwards, we had a lot of help from a team of people from enforcement, RPM, and general counsel. As was said, we met last week with the enforcement group to go over what we had so far. The discussions were, shall we say, lively, and the input was invaluable. There's a vast difference understanding a program by reading trying to understand a program by reading a statute and getting firsthand knowledge from people in the industry. They didn't hold back. We got a lot of good input. So I'd like to thank the enforcement work group, Jason Harris, Terry Maxey, Adam Thompson, Steve Webster, and Gary Garrison. We did make some recommendations for changes. We reduced all of the penalty ranges, and we moved some violations up in class and down in class. One thing Brian Francis has stressed is this is not a final draft. We still need the whole board's input as the experts in the industry. Shouldn't be shy about anything we might have missed or got wrong. At the end of the meeting, we'll have a next draft, or if things are agreed upon, then we could have a final draft to submit to the commission. To put the penalty matrix in context, I want to give a quick overview of how TDLR prosecutes a potential violation. I personally hate it when I don't know the jargon, so I'm going to start with a few terms so it's maybe possible to understand what I'm talking about. I hope I'm not being too remedial. Statutes are passed by the legislature and rules are approved by the commission to implement the statutes. Collectively, statutes and rules we call law or the law. The complaint filed by a complainant is an alleged violation. Alleged is properly used unless and until a final order of violation is issued. A notice of alleged violation, or NOAV, is issued by a prosecutor to put the alleged violator on notice. This is how we tell someone that we think they violated the law. And the alleged violator is called the respondent. I'll use that term a lot. As Ken mentioned, the State Office of Administrative Hearings is where we have our hearings, and they're held with an administrative law judge. Overviewing prosecution, complaints, usually from consumers, go through intake and investigation, and then the documentation and the evidence is sent to the prosecutor. We have 3 prosecutors in what we lovingly call the transportation team, which includes motor fuels. The prosecutor that gets the case evaluates the facts and determines the appropriate disposition of the case. Prosecutor has essentially 3 options. 1, close the case because there was not a violation or there's not sufficient evidence to prove a violation in court. The next possibility is a written warning. We do this when the violation is minor or the respondent has a very clear record or the respondent has made some serious effort to come into compliance. A warning has been made part of Class A's range, but a prosecutor can do a warning on any class violation. Finally, the prosecutor can issue an NOAV when it's determined a violation has occurred and the violation can be proven at SOA. Prosecutor will not issue an NOAV unless they're confident the violation occurred and they can prove it at a SOA hearing. The NOAV includes a proposed penalty or sanction that comes directly from the penalty matrix. If the respondent wants to challenge the NOAV, they can ask for a hearing at SOA. Otherwise, they pay the penalty and/or follow the sanction. Prosecutor has a great deal of discretion when it comes to determining how a violation should be pursued. Always have the ability to issue a warning. There was some concern in our last meeting that multiple violations of, say, stickers, say the Texas sticker with our beloved executive director's signature might be missing from 20 pumps, but the prosecutor doesn't have to issue 20 violations, and normally we wouldn't. We do know the difference between, say, a vandal pulling stickers and somebody thumbing their nose at the rules. Now, the penalty matrix is developed by looking at all the statutes and rules and separating out those that either prohibit something or require something. Those go into the matrix. They're translated into what we hope is plain language. Statutes and rules are difficult to read even for lawyers. Having plain language in the penalty matrix is helpful. penalty matrix is separated into 4 classes, and each class depends on the severity of the violation. Each class has a range assigned. I think it would be helpful to know what the matrix is and what it is not. The most important thing is that it's a guide for prosecutors when an NOAV is going to be issued. It indicates the appropriate penalty range for the violation. Prosecutor works within the specified range to determine the proper penalty for that particular case. The things taken into consideration are the facts of the case, the severity, whether it's willful or intentional, any good faith action, violation history, and the penalty level necessary to deter future violations. Tdlr has as one of its important goals getting people in compliance. Now, the penalty matrix we're working with cites laws and rules that will be effective September 1st, 2020. It is also a notice to the industry of the potential penalties for violations. It tells you what penalty can be levied if you violate a particular law. Excuse me. The penalty matrix does not in itself create law. It just expresses the law that's already on the books. It's also an important tool to make sure that the prosecutors are handling similar cases in a similar way. We all use the same penalty matrix, and when we discuss cases, we discuss them with the penalty matrix in mind. The matrix does not obligate the department to impose a penalty if a violation is found. We've got the warning, closing. We've got other tools. It's not binding on the commission when they make a decision in a contested case. Now, getting into the nuts and bolts of it, the structure, it's the version you're going to see is the same as all the penalty matrices or matrices. I looked that up in the dictionary. It's both are correct for plural of matrix. So we've got 4 classes depending on the severity of the violations. Notably absent is a mandatory progressive increase in the penalty for subsequent violations. While prosecutors most definitely take repeat offenses into account, not being required to increase the penalty for subsequent violations gives flexibility to make a decision based on the facts and circumstances of the particular case. Tdlr has found that requiring separate ranges for the first, second, third, etc. offenses generates confusion and conflict that consumes time and distracts the parties and the judges from the merits of the case. Finally, this simplified approach is consistent with the agency goal committing to streamline procedural steps to ensure prompt investigation and resolution of complaints. Now, some thoughts about our goals. We are interested in compliance. We're not interested in gaming or in gotcha games. If your business follows the statutes and rules, we're happy. We're not looking to levy a bunch of penalties, and we'll work with you to help with compliance. Okay. We mentioned that there were some changes. I want to just briefly go over the changes that we proposed after our meeting last week. Pump sticker violations have been moved down to Class A based on the concerns that multiple violations would add up too quickly. We don't normally prosecute that way, and we understand the concern, so we reduced the penalty. We did the same with records violations. Violations that involve uses of standards were moved up to Class C from Class B. Fuel rating violations, the octane, were moved down from Class C to Class B. And there are some violations that, Chris, you don't have to start on that yet. I'm just doing a brief on this. Knowing violations were moved from Class C up to Class D. These are violations harmful to consumers, and the respondent is aware that they're violating that law. Knowingly is a high standard of proof, and as a prosecutor, I'm going to be absolutely sure the evidence is rock solid before I charge it. I'm happy at this point to answer any questions about what I've covered so far regarding the process and how the matrix was put together.
Are there any questions for Tony at this time? I believe Mr. Maxey has a question.
Yes, sir.
Oh, yeah, overall, I'm tracking with everything. Of course, I was on the call a couple of weeks ago when we started working on this, and it looks like a couple other changes and some things. So I see some of the things have gone down to Class A, and just so I'm clear, I'm kind of looking at it while I'm listening to you. Is there any, can you just clarify or confirm anything that was promoted up from, say, B to C or C to D or whatever? I just want to make sure that I have a full understanding of anything that was promoted to, say, a higher level of offense.
Yes, as I just said, we moved violations that have a standard of knowingly. We moved from Class C to Class D, and as we go through this, we'll see what else we moved.
Okay, if you're going to go through it, that's fine. Yeah.
Thank you, sir. Any other questions for Tony at this time before he begins? All right, Tony, go right ahead.
Okay. Chris has the edited version up, so we'll work with that and see if we can make good sense of it. Sometimes it can get a little confusing, The Class A is the lowest class. We changed the penalty range from a warning letter up to $800. It was $100 to $1,500. If you'll scroll down to the, okay, we moved the sticker violations that are in blue here from Class B to Class A, as I mentioned. Okay, the next section. Now you might be noticing that within each class, we have categories. It's to group things similarly, like these are posting and public information violations, to group similar things to make them easier to find. Okay, next group. Okay, records violations. The work group was concerned that these, like sticker violations, could add up, and circumstances cause large fines. Again, we don't usually prosecute it that way, and we understand the concern though, and so we dropped these down to A's. Okay, next. Okay, those are service companies. Okay, now we come to Class B. We lowered the top end. We raised the bottom end a little bit to so there wasn't such a gap between A and B. Here's a violation. We moved to Class C that I was talking about, the standard violations where businesses don't use the standards that are required. We move those up to Class C. We think those are a little more serious. Maintenance activity. Again, these are standards. We expect licensees to follow the standards. So we're up to Class C on these. We move them there. Okay, next. Okay, sticker, even though our beloved executive director's name is on the sticker, we did move it to a Class A based on the concerns about lots of violations. Okay, fuel quantity. This is a standard violation. We expect people to follow the standards. The fuel quality violations. Okay. We moved this from Class C because of concern that was expressed that the station doesn't have as much control as they would like over what goes into the underground tanks. So we dropped that down to a Class B for problems with the fuel quality. Dealer records, again, went to Class A. Okay. Failure to, I lost the cooperation one. I think you know, you need to go up. Okay. I think go up a little bit, just a little bit more. Okay. Failure to cooperate with the department violations. Actually, we kept it at B. We take it pretty seriously. Go ahead. Okay, records, we move to A. A new owner of a device not registering and the owner not submitting the documents, we move from Class B up to Class C because we think this is important. Go ahead. Okay, Class C, we lowered the upper range. It's $1,000 to $3,000 or 1 year probated suspension up to revocation. Go ahead. Okay, these are moved from Class B. As I said, we expect the standards to be followed. Continue. Violating an order of the executive director to stop sale of motor fuel. We move to Class D because we think that's very serious. And we've got a knowingly, we moved up to Class D. And I talked about the fact that's a pretty strong standard. Continue. Okay, this is the octane issue, the fuel quality issue. We move to B. The fuel quantity is these are standard type issues, not using the correct standard. Continue. Okay. This is another knowingly. Someone knowingly used an incorrect weighing or measuring device. If we can show that they did it knowingly, then that's a serious offense. Go ahead. Okay, we talked about submitting registration, move from Class B, okay. Okay, and Class D is the most serious, obviously. We did reduce the range from 3,500 up to 5,000 and or up to revocation. We removed the honesty, trustworthiness, and integrity because that is a problematic standard with sunset. And we brought in the knowingly violations and violation of the executive director's stop sale. Okay. Okay, that's the end. I went through that pretty quickly. What questions, comments, concerns? I can't believe you did that. Don't you know anything about motor fuel? Any questions?
If anyone has any questions for Tony, if you don't mind just kind of raising your hand, I'll see if I can be looking for you. Any questions concerning the penalty matrix at this time? As I said, we made some changes to it after our last work group meeting. So you'll see that a lot of the recommendations that you made, comments that were made, have impacted the product that you see before you. So Wes, I believe you have a question.
My question is, I saw on there a couple of places where we have violations for service companies. And my question is that for the service technician? When we talk about revocation of licenses, that's individual licensing being revocated, or is that the entire company that's going to be the potential to have their license taken away?
I'm going to tell you first that you got to really do something serious to get your license revocated. I'm looking for.
I believe it was in the B, in the B range.
Okay. If it is the action of a single technician and clearly not something that the company was involved in, then the company wouldn't be issued a violation for that.
I'm just concerned that's failed to perform a device maintenance activities in compliance with commission rules. That's extremely vague, and it leaves a lot to be open to interpretation, of course. But I mean, I don't want to see where an entire company is penalized, whether it's my company or not, penalized for the action of one. That's the reason I'm asking the question. It's under the service company header. It doesn't differentiate between the company and the technician in that. That's why I was bringing it up.
I think the Honorable Brian Francis has a comment to make.
Brian Francis speaking. Mike, you obviously don't know me well. Honorable has never preceded my name. I usually say Your Honor, but never Honorable. Wes, you raise a good point. We could do a couple of things if you'd like and make it get you comfortable. One, we can have that penalty broken out to where it attaches to the technician and it's also there with the company. I'll just tell you with my experience when I was the deputy over at the Real Estate Commission, we had a lot of contact with this in regard to the broker and the salesperson. The salesperson was doing a lot of stuff. The broker, we'd open up the complaint against both of them. And then we'd look and see who's responsible. And a lot of times we would determine that the broker had training that said You must provide the proper disclosure. You must make sure that you review the appraisal agreement. You must make sure that the contract is signed in a timely manner. And it was the salesperson who was being rogue or going off, off on a beaten path of their own. And we made that decision to separate it out. We'll do that same thing here. But if you'd like, we can say in that same area, service company, maintenance activity violations, and then service technician, have it separated or for both of them, if that helps.
It helps when you unmute the mic before you start talking. That would help clarify it. I mean, it just leaves to interpretation where some people may see that. First thing I saw was, whoa, the whole company's going to get in trouble for one guy. When we have, and Adam can speak to it as well, when you have multiple technicians out there, you may have some that do things that aren't according to the company's policies.
Well, we take that into account, and I think that Mr. Francis's idea of breaking it out is good. One thing to realize is that the company does have to supervise their employees. But a rogue employee isn't something we go after a company for.
Any other comments or questions? John, I guess we're okay with making that change in the penalty matrix.
I have a question.
Okay. Who said that?
I said that.
Oh, there you are. Okay, I'm sorry. Go ahead.
On each dispenser, how many sticker would go for unleaded and a diesel? Because some of the dispensers have a high flow diesel, so that would have a different sticker, sir, on the dispenser. Did I ask the right question?
I don't know the answer to that question.
Hey, Jessica, you got an answer for that?
I do. This is Jessica Escobar. Sir, are you talking about how many stickers are needed per side of the dispenser?
Yes, Jessica. Also, if you know that the high flow diesel has a different nozzle on the diesel side. So to identify, because we pay different price for the sticker when we apply for the sticker, we pay different price. So to identify each dispenser, are you going to send a different sticker for each?
No, sir. So the only requirement would be in the rule that you have a sticker on each side of the dispenser. So you just need to have one on each side. You don't need one on every side. You just need one on each, on two sides of the pump, basically, on two sides of the dispenser. You don't need one on all four sides of the dispenser. So you would just need the two sides of the dispenser.
So Jessica, my question was, is it unleaded has a different sticker than the diesel, or they all looks like the same sticker?
Are you talking about the posting requirements or the consumer? Oh, okay. So yes, you would need all of the individual posting related to each type of fuel. So yes, you'd have to have each of those, and those would all be required. And those, if, for example, something was missing, those would be related to those posting requirements within the matrix.
So now,
I believe he's actually referring to octane levels.
Not octane levels, sir. No.
Octanes,
no. TDA, we used to get the round sticker.
The feedback.
Yeah.
The feedback sticker.
Yeah, correct. Yes, right.
It's just one on both sides of the pump. That's all you need. So if somebody can pick up a nozzle, they should be able to see the feedback sticker on that side. And you only need one per one side of the pump, not per product.
So Adam, it's only one sticker for whole entire dispenser, but either it's 0
Not the whole dispenser, one side.
One side, okay. One side.
Right.
So
and
you need it on both sides.
Right. So that's our new consumer. I actually have it for you. So here you go. These are the new Tdlr stickers.
Yeah.
And you need one of these on each side of your dispenser.
And that's it. No more stickers.
No. That's
Okay.
it.
That's it.
One on each side.
Gotcha. Thank you.
You're welcome.
Thanks, Haraj. Any other questions or comments at this time concerning the penalty matrix that's been presented by Tony? Jason?
So just a general question. In your other programs, is it common for the 1 full year suspension to be included in Class B?
I work TOW and VSF, and that program has that. So it is used, or it is in the matrix. It is very, very rarely used. We don't want to put people out of business. That's not our job. Our job is to make sure we have compliance with the rules, protect Texans, and have businesses operate.
Understood.
So,
We had this conversation last week with respect to anything that involves postage or signage or stickers or decals, that sort of thing. I think there was a concern expressed by multiple folks in that call about, missing a few stickers here and there or having people remove them. I understand what you're saying. You guys use a lot of common sense, and for each individual case, look at all the materials and information available. I think it gives just a general unease having anything that it involves posting a sign or a sticker be linked with a suspension. That's kind of the general statement I wanted to make.
Hey, John, you got a little bit more you can add? Hang on just a second. John, you got a little bit more you can add?
Yeah, Mr. Harris, just to kind of address that point about the suspension being in Class B, I just went through and checked. A lot of our programs that deal with kind of people going in repairing equipment, like the air conditioning, electricians, they do have that in Class B up to the 1 year full suspension. And I think the other thing to kind of keep in mind with this penalty matrix is the vast majority of people who work in these industries will never see this penalty matrix. It's people that have committed violations where people have filed complaints on. And I understand the point with the stickers, which is why we kind of moved the majority of those sticker violations and record violations up to the Class A, which at most is an $800 penalty. Again,
I appreciate that.
Yeah, again, what we try to do is we try to take a common sense approach to these things. And it's all the cases are going to be very different in the sense that they're going to be fact specific. There may be somebody that files a complaint saying that this one retailer does not have stickers. Well, our investigators are going to go out there, contact the people that they need to contact, and it may be the fact that somebody went in there and just pulled those stickers off. If that's the case, we're going to close that case because it's not warranted. But again, it's going to go through that investigation process, and that's going to give us the information for the prosecutor to make the best decision, to what that specific circumstance is.
Okay, understood. The only distinction I would make is and I don't have familiarity with all of your programs, but I'm guessing the most of them are licensed individuals. The only difference I think with this program, we're talking about a retail establishment that has a license. And there's a lot more potential for complaints, a lot more potential for individual investigations that may reveal the issue than there are potentially with a single individual. And I don't know what I would recommend to remove some of that discomfort, but I just wanted to make it clear that this is a little bit different animal.
Well, I think the vandalism, sorry, this is Adam Thompson. I think it's the vandalism standpoint, especially out at the gas pump, that happens quite frequently. And sometimes it's the same pump over and over and over and over again, whether it's card skimmers or just damage, period. And so if you get a complaint one day, we fix it, get a complaint the next day, you fix it. I think the fear is it just continuously happens, which sounds like it doesn't, or that's almost impossible, but it does happen. And so from the standpoint of Jason, If it's just this convenient circumstance and it keeps happening, it looks like he's being negligent. Being that it's in that class, it's kind of a worry that it's setting them up for that worst case scenario. And so, is that a huge, is it a huge factor that requires that, or could we move it to class A where if he can't argue his cause that it was negligence, that it would be up to an $800 fine? Or, if we start getting into it, how deep is this investigation go and how far when it could look like what it's not? And that's where I just kind of stand on that point from Jason's side.
Hey, Brian, you had a comment? Brian, Tommy, hang on just a second. Brian, you got a comment?
Chairman, thank you. Brian Francis. Jason, thanks a lot for the points. And Adam, thank you also for chiming in. I'm okay with us moving it from B to A. Like I said earlier with is that, we're talking about B to A, right? Is that the conversation, right? Or C?
Yes.
Where is it at?
B to A.
I'm okay to moving it. Just like I said earlier with our rules, and the same thing will be true with this penalty matrix. We can put it out there and start it and get a sense of how things are flowing and what's happening. We need to get an experience of these violations with Tdlr. It doesn't have to be perfect on the first day when we start this penalty matrix. So we can move it to A, and we can come back to the group later and we find out, Jason, in 6 months that this is crazy. Here's what we're finding, and we need to move it back. We'll come back to the group and say, hey, here's been the data that shows it probably should be at a higher penalty, but we can start it in that direction. I'm okay with that.
Yeah, that's a great point. I'm glad you mentioned that. Is that I can tell you through the history of kind of my history through Tdlr, there have been movements within our penalty matrix through the various programs as we begin to start seeing severity occur in some, and maybe that it's not that big of an issue, that we move that back and forth. So I've seen that happen within our agency. Hey, John, you had something?
Yeah, I want to address Mr. Harris's question. Is there a specific one in Class B that you were referring to? Because I thought we had moved all the sticker violations into Class A already. We may have missed one.
There's two that discuss posting or providing information to the public, I believe. There's the dealer failed to post the automotive fuel rating and failed to prominently display required signage regarding alcohol content. And just to clarify, my concern is really not with the classification or the penalty amount. It's more related to the potential for suspension of a license.
Can I speak to that? If you have a situation which you described where somebody's ripping these stickers off, one thing you could do is document. Take a picture with a timestamp on when the sticker's there, and take a picture with the timestamp when it's gone. Do that a few times, and you've got evidence that it's not your doing, and that would certainly be taken into account.
Mr. Maxey, you have a question?
Couple of things. One, I think that, last suggestion is good. I think one of the problems some of us run into is, if it was up to me personally to take that picture, I would do it fine. But a lot of times these things are handed down through levels. If you've got, multiple stores, and I couldn't even imagine how many employees Buc-ee's and those guys have, but it's easy to sort of talk about, amongst us decision maker types here, but it's hard sometimes to get right down there and make sure that you've got, those photographs and things. But I mean, I agree, it's a great idea. My main question was, does the suspension really have to be in the Class B? I mean, is there something in there that just says we got to have a lever of suspension on this, or can in Class C you've got suspension and revocation stuff? I mean, maybe that should just be taken out of that as a possible penalty. Obviously, the progression is that the penalty dollars are higher.
This is Jason. That would be my recommendation as well, because we're dealing with license holders that are not individuals. I would like to see the suspension removed if possible.
John, Mary Winston. John, just announce yourself and what do you have?
Yeah, again, John Medlock, Chief Prosecutor. Because some of the ones that we do have in here are for people who have performed with like expired licenses, and we have seen that quite frequently in other programs where we do kind of want that threat of some sort of penalty. What we could do, instead of completely removing it, what if we put up to a 1-year probated suspension, where what a probated suspension essentially would be is that we are going to say we're going to suspend your license, but we're going to probate that for up to a year. It could be 6 months, depending on whatever the sanction is. And so long as you follow the laws and rules during that time period which you're on that probated suspension, you can still conduct your business as needed. Would that ease any of the concerns?
Yeah, sure.
Okay, Mary Winston here. Is there any more conversation or discussion? Our presiding officer, I think, is having some technical difficulties.
I had a question based on kind of Wes's, and this is Adam Thompson. His question was about the repercussions on a company with a technician who basically did something. Are we going to be able to allocate technician to and from company? So if we hire, obviously we get them tested and we allocate them to the company under the company license. And if we terminate or whatever reason we part ways, we deallocate them from the company. But then there's another law that says that technician has to have either a sole proprietor license as a company, or he can't operate just under his license number. So in that way, do we give them a direction, or I just want to know if there's an allocation and reallocation or part to make sure we know, or y'all know, who's working for what companies, and when they leave, is there a form to fill that out? And I haven't seen that yet, so I just want to clarify that, to clarify this law for myself.
To my knowledge, Jessica might know more about this. To my knowledge, there's not anything where we keep track of technicians and what company they work for.
This is Jessica Escobar. Adam, there isn't at this time. We don't have anything that has the company name tied to the employee or vice versa. So that's something we can certainly look at as we continue to roll things out. But when information is entered online, it's all tied to a company and to the technician. So as that device performance review online is getting set up, they have to enter it through a company. So a tech wouldn't just be getting online and entering something, it would be going through that company. So hopefully that alleviates some of that, but definitely that'll be something that we look at, is tying the company and the technician together. We can look at that in the future.
Yeah, that works. Sorry. My only concern is if we perform a service, you don't fill out that form online. So now that technician is linked to the company without a service report, just doing basic repair. And so that's where how would they link that customer or that employee to a company? But what if you terminated the day before, he went out on his own, pick up that customer, and now he's still linked without any kind of documentation? So it would just be us providing records, I'm assuming, an investigation, and y'all would come to us and we would show, no, they're not with us as of this date, and we could figure it out. But I just didn't know if that would help in law or whatever, or help in this statute here.
Yeah. My apologies, everyone. I'm sorry. Go right ahead, Brian. I think Wes has got a question after me.
Adam, this is Brian France. Adam, you're absolutely right that when that complaint comes in about failure to do it right or failure to have the timing, we're going to get all the documents that say, here's the company and here are the employees that were there. If that employee's gone or wasn't there at the time, then we're going to, sift that out. I will tell you that you do not want the law and you do not want Tdlr to have you telling us who's working for you at every given moment, because they're going to drop and they're going to be adding, and all of a sudden now you didn't report in 10 days that an employee left. I said that gets too down into the weeds of your business. When that complaint comes about a pump or comes about a facility, we're going to be able to drill down to which service company was over that and which employees were engaged on that particular pump at that given time. And so the records will help us get there. We don't want to build another system around keeping track of the movement of employees going left and right and back and forth. I've done that before with, the real estate commission. We've done it before with air conditioning contractors, and it's a fool's folly to try to track that.
Okay, I believe Wes, you've got a question?
I just wanted to make a comment. There's actually a current form with the TDA. It's the RMW 709. That is for when a technician changes from one company to the other, because according to them, they are required to be registered with a company. It's the RMW 709. I know that's that nasty word TDA, but it is a form that's existing right now.
My boys in TDA, Dan and I, we do like virtual DAPs all the time. I think what we're getting there is that a technician can't work solo. They've got to have some type of connection and arrangement. The back and forth is something that we just don't want to have a rule that we beat people up for because they didn't tell us that somebody they didn't like, who was a bad employee, they let go 2 days ago. But we'll always be able to drill down to the specific complaint, the pump, and which company and which technicians were involved in it. And then we can sift it out. We're not going to levy a penalty without knowing the facts of who, when, what, and where.
Yeah, and this is John.
Oh, go ahead, John.
Yeah, I was gonna say, I think all the commentary has been great on this, and with respect to this, the evidence is always going to drive us in the decisions that we make. So if it's a situation where it's a rogue technician, we see that all the time in like our air conditioning. There'll be technicians out there that are doing stuff when they shouldn't be doing stuff, even while they're under the employment of an air conditioning contractor. So basically, the evidence that we collect during the investigative period is going to drive those decisions. So if it's a bad actor, we're going to see that, and the company's not going to be penalized for those bad actors. Again, it's going to be very fact specific, very evidence driven, and we're going to collect everything that we need as far as documents, witness statements, before we even come close to enacting this penalty or looking at the penalty matrix for an NOAV.
Okay, any other questions or comments? Okay, as you can see, there's been quite a bit of work done on the penalty matrix after our initial meeting with the work group. We took your comments into consideration. As you can see, moved them around. Again, I would tell you that based on my history with this agency, we are very cognizant of the fact that we want to keep people in business. That's not our purpose. We want to ensure that that the industry continues to flourish and prosper. Of course, still providing for consumer safety. So that is what we take into account on this, and just know that there's always the ability to come to us. And I'm sure that you'll find out is that the industry will probably start coming to you with a lot of questions as well that you'll be able to relate to us. So any last parting comments or questions concerning the penalty matrix? Yes, John.
Unmute, John. Unmute, John.
Thank you. Sorry about that. Again, I just want to kind of make it clear, even though we've not regulated you guys yet, we have regulated other industries that have businesses and consumers and employees that are in some of the similar veins as what this is. So I think we've got a pretty good track record of making sure that we only enforce this penalty matrix against the bad actors. 9 times out of 10, we try to get compliance in all these programs and on all these alleged violations. And you're going to definitely have the opportunity to speak with the investigator, speak with the attorney, speak with all of our staff regarding any complaints that do come in to tell your side of the story, because that's what we want. I don't want to make a decision in the vacuum. I want to make sure that I have all the best information that we have possible before we even get close to start issuing this NOAV.
Mr. Sherlock, I believe you had your hand up. No? Okay.
Sorry, thank you.
Any other questions or comments? If not, at this time, I would ask and look for a motion to accept the penalty matrix that's been presented.
Motion made, and they put that probated there, so yeah, motion made as it's presented now.
Okay, we have a motion by Mr. Maxey.
I second that.
Second by Mr. Thompson. Okay, at this point in time, we'll go.
Mike, can I ask Mike? Can I ask a
Sure,
question?
go right ahead, Dan. Yes, go right ahead, Dan.
I thought there were going to be some changes that were going to be made to this. Are we going to see that verbiage before we vote on this?
The penalty matrix that you have before you, I believe you had a updated penalty matrix sent out to you on Friday. Is that correct, Daniel?
No, I mean, part of the discussion earlier, someone said,
Oh, yes.
we'll make changes to that.
Yes. These changes will be notated in the penalty matrix that is distributed out for distribution to the commission. We'll have the changes that have been discussed here. Because this is a recorded meeting, we have that information and we can refer back to it to make sure that it is implemented on our penalty matrix.
So we're voting on it as changed verbally.
Changed verbally, yes, sir.
Is it, Chris, aren't you
Are you updating
taking
that?
care of these?
So I think, Chris, are you updating it on the fly? Okay, so what you have before you, if you can go ahead and pull that back up, the changes we just made.
They are right now.
Okay, so it's there. I'm sorry, I'm actually trying to look at everybody here, so I wasn't looking behind me. Okay, there we are. And I believe that's what was discussed. John, did you have something else to add?
That's what I was going to say. Is it looks like it had been updated with that verbiage.
Okay.
And this is Brian Francis. Chris, are the changes today reflected in blue?
Yes, sir, that is correct. So we had sent out two versions of the matrix, one that had the changes already made and one that tracked the changes. This one just shows today's changes.
Dan, if you'd like, we can take a little time to have Chris and them go through the classes so you can see that they were able to capture the blue changes from today's conversation and incorporated those if you'd like.
No, Brian, that's okay. I just want to make sure what we were voting on because I knew there were changes being made. And if we're just going to, they're going to reference back to the recorded conversation, that's fine. I mean, I remember what they were, but I didn't know if we were voting on the old document or the updated one as verbally discussed. So that was the key thing.
Okay.
It'd be, actually, it's both. It's the discussion that was made plus the updated document before you. So it reflects that discussion. Okay. Any other questions or comments?
Chris Rice, Management Analyst with Enforcement. I just wanted to confirm that these are the only changes that were requested from the conversation today.
Hey, Jason, you had something, sir?
Yeah, can I get John to explain to me again the difference between the full and the probated suspension? I think I caught most of it, but I want to be 100% sure.
Okay, sure. Not a problem. So if we take a full suspension against somebody, that means we're literally suspending their license and we are preventing them from performing the work in which that license allows them to do. If we take a probated suspension, we essentially say that we're going to suspend that license. However, we are probating it means it's not, the suspension part is not in effect for that duration. So it could be up to 1 year, meaning you can still continue to work. And so long as you follow the laws and rules and don't get any other orders against you during that period in time, during that probated suspension, we wouldn't seek to try to enforce that suspension. So it's kind of a really big warning that we're keeping our eyes on you, but yet you can still operate without, being suspended.
Okay, thank you very much.
Any other questions or comments at this time? Okay, Delia, we can go ahead and take a roll call on this. We have a motion by Mr. Maxey and a second by
Thompson.
Mr. Thompson. Okay, yes, we can go ahead and call roll.
Mike Arismendes,
Yes.
Wes Nance,
Yes.
Adam Thompson,
Yes, ma'am.
Raj Ali,
Yes, ma'am.
Jason Harris,
Yes.
Steve Boyd,
Yes.
Lane Worthington,
Yes.
Gary Garrison,
Yes.
Terry Maxey,
Yes.
Adam Colby,
Yes.
Dan Hunter,
Yes.
Brad Schulke,
Yes.
and Steven Skurlock.
Yes.
Motion passes.
Okay. Great work today. We actually took up the penalty, the rules, criminal conviction guidelines, and the penalty makers. Great job. I don't think that you realize the enormity of what you've just done. It's kind of set forth this industry and where we'll be heading this path. As was mentioned earlier, as we begin to start seeing changes in this industry, and you may have something that you want to bring before the commission through the through writing it through this work group, we'll be able to take that information, expand it out, and look for trying to get possible changes if needed within this industry. The biggest thing that we want in this industry is to ensure that we have a solid industry that ensures a prosperous growth of business, at the same time providing for consumer safety. That's always the two things that we look for within any program that we have. So, Mr. Francis, anything else to add at this time?
Just really pleased with the work. It's a lot of heavy lifting in addition to your regular real jobs, the ones that put food on your table and that you're paid to do. So I'm very grateful for the effort. Again, I want to thank the staff for all their effort. This is what collaboration looks like. This is what government's supposed to feel like, that it is something that we all get to build together. Has a consumer protections, but also speaks to the needs of businesses to be able to operate without us unduly looking over their shoulder and being in their day-to-day operations. Mike, as we get close to the next agenda item or get close to the dates, I would like for us to look at maybe a late September, early October meeting time period. That would get us past the sunset decision meeting, just in case there's something that comes out of that that we need to share with the group. But what a great job. Excellent job. Mr. Chairman, you even did a good job too, man.
I appreciate your approval. I'm going to go ahead and take up item J and K at the same time. J is recommendations for agenda items, at the same time discussion of date for the work group meeting, as was suggested right now by our illustrious executive director, to have a meeting somewhere at the end of September, first part of October. We may look at a October date, first part of October, that will probably give us the ability to kind of gather our bearings after the sunset meeting and look at the direction that we're at, so that we can kind of bring together a possible recommendations or anything that changes within sunset. So at this point in time, what will happen is Delia will poll each and every one of you for a date early part of October. When I'm talking early part, I'm talking about like within maybe the first 7 days of October, so that you have some idea about a possible other meeting. If we have not brought up or discussed anything that has to do with your industry, are there any agenda items that you would like to discuss at our next meeting? And if you need to think about that, feel free to go ahead and submit that to Delia at the same time when you're submitting, when she polls you for the next dates. Okay, so not hearing any suggested items, or you have now a projected date, I will go ahead and consider this meeting adjourned. I appreciate all your work. Thanks for everything that you've done, and we look forward to continue working with you here at TDLR. Thank you, everyone. Have a good day.
Thank you, everyone.